Good morning and welcome to today's presentation on human rights in the workplace. Today's topic is termination of employment. Today's webinar is the second in a three-part series on human rights in the workplace. The first session in September covered what are human rights, and that is available as an on-demand webinar on CPLE's YouTube channel. The third part in our series will be on November 16th at 10 a.m. and in that last session we will be covering the topic of resolving disputes. So my name is Jessica Steingard. I am a staff lawyer at the Centre for Public Legal Education Alberta, or CPLE for short. And our mission is quite simple, and that is to provide Albertans with easy access to the laws and make it more understandable for them. So we produce a variety of tip sheets and booklets and other print resources, as well as websites, videos, webinars like this one that explain the law in an easier to understand way. We also have two individuals joining us from the Workers Resource Center this morning. So we have Carolyn Cron, who is the Interim Executive Director, and we also have Quinn Blythe, who is the Sexual Harassment Legal Specialist. They'll explain a little bit more about the Workers Resource Center near the end of today's presentation, but just know that they are an Alberta organization based in Calgary that supports Alberta workers. A quick disclaimer that this presentation contains legal information only and is not intended to be legal advice. And as well, we would like to acknowledge the generous funding provided by the Department of Justice Canada to make presentations like this one possible. If you have to leave early, you'll be prompted to complete a quick evaluation form. It should take about 30 seconds, but we really appreciate your feedback on today's session. Okay. We're going to start today with a quick poll just to get a sense of where everyone is at. So that's going to pop up on your screen, and I'll give everyone a few seconds to answer that. Perfect. Okay. And so a majority of you are somewhat familiar. Okay, so hopefully we can add some more value today and kind of connect a few dots that maybe you weren't aware of, but let's get started. Okay, so where do we want to go today? We're going to start with a little bit of a refresher on discrimination. We talked about that in the September webinar, but we'll just do a quick refresher just to kind of set the stage for today. Then we're going to lead into a bit of a discussion on the different types of terminations, just to make sure we're all on the same page. And that will inform our discussion on the interaction of human rights and terminations in the workplace. We will move along to sexual harassment. We're doing a bit of a spotlight on the issue of sexual harassment in the workplace. If you joined us in September, you know that we talked about how prevalent it is right now, and there's a lot of work going on to educate, prevent, create awareness for sexual harassment in the workplace. So we're going to spend a few minutes talking about that again today. And then we'll finish with some resources, which Quinn will lead us through, just so that if you need support, then there are options available. I noticed there's something in the Q&A chat here. I'm just going to pull it up. The audio is correctly. Is that my audio? Is it correctly for everyone else? No? Okay. Just double checking because sometimes my little microphone likes to go off. So there we go. Okay. Quick note about the Q&A as well. We will be taking questions at the end. So if you have any questions throughout, just pop them in the Q&A chat or the Q&A function, and we will get to them at the end. We're going to try and leave at least 10 minutes for questions. And Natalie, like I said, Natalie's the face behind our CPLE logo there. She will be posting some links throughout today's presentation for you in the chat, so you can watch for those there. Okay, let's jump into human rights at work. So human rights laws say that an employer cannot discriminate against any person with regard to employment or any term or condition of employment. So what does that mean? Well, we're really looking at the entire employment process. So this starts at the recruiting stage. So how is an employer recruiting? What's their process? What do their ads say, for example? right through to the hiring. So we all know that there's those questions you can't ask during an interview. They're not appropriate. We're also looking at terms and conditions. So that could include things such as pay and whatnot. Benefits. Does everyone have equal access to benefits, or some people being denied access to benefits? There's also ways that workplace policies can be discriminatory. So we look at those as well. And finally, through to termination. And as I mentioned today, we are going to be focusing on termination, specifically in a non-union context. I do want to note human rights laws do apply to unionized workplaces, but there are a few other considerations given the existence of a collective agreement within a unionized workplace. So today's discussion will focus largely on non-union workplaces. Okay, as I said, a quick refresher on discrimination. There is a legal test for discrimination. These are the 3 elements that someone who is raising a complaint of discrimination must show. So the first is that they have a protected characteristic. We went through the list of protected characteristics in September, but I will also run through them quickly today. So the first step is a protected characteristic. The second step is a negative effect. So one example of a negative effect can be an employer or employee terminating the employee relationship, which is what we're talking about today. And then the third is really linking those two together. So showing that the protected characteristic was a factor in the negative effect. So they can't be separated. There has to be a link between the first and second elements there. Protected characteristics under Alberta and Canadian human rights laws are as follows. So it's a giant list. I'm not going to go through each individually, but these are the different characteristics that are protected here. I will note that the last 2 that have the asterisks there, those ones are under the Canadian Human Rights Act only, not under the Alberta Human Rights Act. So when we talk about protected characteristics, it's important to take a look at this list because there are certainly different reasons why someone may feel that their workplace is not a good place to be. There may be some types of behaviors and whatnot that someone may think are discriminatory, but if they do not fall within this list, they do not relate to something on this list, then they are not protected under the under human rights laws. So this list is important. Okay. Going to move through to different types of terminations then. We're going to be talking today about 5 different types of terminations. And this is really to just set the scene for some of our discussion later on about human rights can play into these different types of terminations. So the 5 that we're going to discuss are termination without just cause, termination with just cause, quitting, a layoff, and constructive dismissal. These are different ways that both an employee or an employer can end the employment relationship, and we'll see kind of where each of these fall. These types of terminations are not based in human rights laws, but like I said, there's a lot of overlap into how they play into human rights issues when it comes to terminations. Before we dive into each of those different types, I want to do a quick kind of caveat or aside here. So last time we met, we talked about how Alberta and Canada each have jurisdiction over different types of workers in Alberta when it comes to human rights laws. So we talked about the Alberta Human Rights Act and the Canadian Human Rights Act, and that they apply to different types of workers in Alberta. There are other employment-related laws that work the same way. So in addition to the human rights laws, we also have the Canada Labor Code, which applies to that same group of employees, which is federally regulated employees or certain industries that the federal government has jurisdiction over. And that flows right from our Constitution. So that's not something that, is just being made up or some sort of divide. That flows straight from our Constitution, that divide there. So when we look at, again, those employment laws, we have the Canada Labor Code that operates federally. And then in Alberta, we also have the Employment Standards Code, which is a different law that applies to Alberta workers. I'm not going to get into different employment laws and certainly not into a discussion about employment standards laws today. I'm just saying that as kind of a preface, because we are going to mention a little bit of that throughout the discussion. If you want to learn more, we have a lot of resources on these laws. And one of our links that we'll talk about at the end, one of our web pages, goes into more of these laws in detail. So the only thing I want to set out here is that there is some distinction, that the same laws don't always apply to every type of worker in Alberta. Okay, let's start with a termination without just cause. So this is a termination by the employer. And in this case, it's important to remember that the employee, I'm going to say, usually has done nothing wrong. Employers can usually let an employee go, even if the employee has not done something serious. But in order to make that legal, they usually have to give them a notice of that termination or a pay in lieu of notice. So we generally understand notice as working notice. So you have to work out so many weeks and then your employment ends. But what's more common is pay in lieu of notice. So an employer goes to terminate an employee and they say, okay, we're going to give you, X number of weeks of pay to compensate you for terminating your employment. There's a few kind of different notices, though, I should say. So statutory notice, again, I talked earlier about the Canada Labor Code and the Employment Standards Code. This is where those Employment Standards Codes come into play, is talking about notice. They both set out a statutory amount of notice that's based simply on length of employment. And it's also important to note that an employer cannot contract out of this. So an employee cannot sign a contract saying, well, the statutory notice might be 3 weeks, but my employer is only going to give me 1 week of notice if they decide to terminate me without cause. An employer cannot contract out of it. But that's not the only type of notice. Some of you have probably heard of this other type, which is called reasonable notice. And this is a completely different regime. This is based on common law, or judge-made law, as we sometimes call it in Canada. And this recognizes that for some types of workers, the statutory notice is not really sufficient. So it looks at more than just the length of employment. It looks at other things such as someone's age, the type of employment they're doing, and whether or not there's similar employment that they'll be able to find. So really, this recognizes that an employee with specialized knowledge or someone in high-level management should probably get more notice than the minimum standards, or might be entitled to more notice than, say, the 3, 4, 5, 6 weeks under the minimum standards laws. So what a court would do is, if you thought that you were entitled to more notice, is they would look at different types of work that are similar to what you're doing, these different factors, and draw similarities between your situation and other court cases that have similar factors to determine what length of notice you might be entitled to. Again, I'm not going to go into this anymore. I just want to kind of highlight this as different ways of how termination without just cause operates. And a third source, I guess, of notice is in a contract, obviously. So sometimes an employee and employer will agree to a notice period. Again, it cannot be less than the statutory notice period, but they may agree to a notice period in a contract. Okay, so now that we understand a little bit about a termination without just cause, which is just that, there's no cause for the termination, but is allowable as long as there's notice. This leads us into our discussion of a termination with just cause. So just cause is actually a pretty high bar from an employer's perspective. There needs to be severe misconduct. This could be one serious event, or it could be a series of events where the employee is reprimanded for their behavior, but does not change their behavior. So you might get a situation where someone does something, and let's say they get a verbal warning, and then they're written up, and then they're written up again saying, if this behavior continues, then we're going to terminate your employment. And then the behavior happens again. And so the employer moves ahead with a termination. From an employer's perspective, like I said, though, this is actually a pretty high bar, and it's really important to document incidents in order to prove that there is just cause. When it comes to a termination with just cause, though, there's no need for a notice of termination or severance pay. The employee is owed their wages up to when they're done work. So again, the purpose of this discussion really to contrast the termination with and without just cause. Another type of termination starts with a temporary layoff. So temporary layoff is usually used where there's not enough work for whatever season the employer is in. So it starts with a layoff notice. So the employer gives the employee a layoff notice, and then one of two things usually happen. First, the employer can then recall the employee. Let's say work picks up again, or it's through a certain season, and then they can recall the employee. Employment laws usually set out a time period for recalling an employee. They can't just indefinitely, there's not an indefinite layoff. There's a certain period of time. I won't again go through what those periods are because they change in the Canada Labor Code or the Employment Standards Code. There was also changes made to the Employment Standards Code because of COVID, and there being significant layoffs during that time. So just know that there is a recall period. If the employer does not recall the employee, then they're deemed to have terminated them. And at which point, termination notice and whatnot termination provisions would come into play here. Again, I would encourage you to look at the Alberta's Employment Standards Code and the Canada Labor Code that have more specific procedures that are followed when it comes to a layoff. The fourth type of termination is quitting. So this is now where the employee is the one terminating the employment relationship. Again, an employee can leave their job at any time. They can choose to, but there's also sometimes a requirement to give notice to their employer. So not just walking off the job one day. The Alberta's Employment Standards Code does set out different notice periods based on how long you have been employed with them. There's also a whole list of exceptions, as the law is good for. There's a law, and then there's a whole lot of exceptions to that law. But know that is set out in the Employment Standards Code that an employee must give notice. Another spot to look to for how much notice you must give is an employment contract. I know I've had employment contracts where it'll say how much notice I must give my employer if I intend to leave. And so that's another spot to look there. And the final type of termination we're going to talk about is constructive dismissal. This one is a tricky one. And this one is actually not set out in any type of legislation. It is a type of termination at common law or judge-made law. So this is one that plays out in the courts. So the questions we ask when we're looking at whether or not something is a constructive dismissal is, did you feel like you had no choice but to quit your job? So sometimes the reasons you feel like you have no choice is, did your employer change a fundamental term of your employment contract without you having any say? Examples of a fundamental change could be your job description has changed drastically. Perhaps your salary has changed, your hours of work have changed drastically, or your location of work. If all of a sudden your boss says, okay, next week I need you to report to work in Calgary and you live in Edmonton, well, that's might be somewhat difficult for you. So that's one example of where constructive dismissal might come into play. Another question we ask is, did your work environment become so hostile that you could no longer stand it? So examples of a hostile work environment include if you're being harassed or bullied and your employer is not doing anything about it, even after you report it. We also see examples in case law where employers or coworkers do everything they can to get a person that's being harassed. They may be harassing them, but they harass them to get them to quit their job or to even get them fired from their job. And so these are examples where constructive dismissal may exist. A quick note, constructive dismissal does not exist where your employer makes small or reasonable changes to your job. So, slightly changing your hours of work or doing something that's, reasonable and doesn't hugely impact your work, that is not an instance of constructive dismissal. There's also no constructive dismissal where you accept the changes that your employer proposes. So I've had friends, for example, that have agreed to, say, a lower salary for a period of time because of economic downturn, with the intention of that salary being paid back later on. If you agree to accept a lower salary for a period of time, then that's not an example of constructive dismissal because you've agreed to that change. The final note I want to make about constructive dismissal is that it can be really difficult to prove. Like I said, there's no legislation setting out constructive dismissal. So it is something that is done that plays out in the courts. So if you feel like you're in a position of constructive dismissal, I would encourage you to contact a lawyer or seek legal advice, because it is a difficult situation. And there's a number of cases where someone has claimed constructive dismissal, but the courts find that it does not exist. Of course, there are also cases where someone claims constructive dismissal and the court finds that it does exist. So it can be a tricky one. Okay. I just want to make this point here, though. When Carolyn and Quinn and I were talking about this presentation, this was one thing that was stressed, is that do not quit your job before talking to someone. So if you feel like you're in a position where you have little or no choice in your job, you're frustrated, you can't stand it, you're just ready to be done, but there are other factors at play, like there's harassment or something going on, talk to someone first. If you quit your job without getting legal advice, it may have other consequences for you. So, for example, employment insurance is not usually available to someone who quits their job. So if you feel like you're in a position where you're just like you can hardly hold on, just talk to someone and get some legal advice first, and so that you don't create other complications for yourself. Okay, how do human rights play into terminations of employment? So moving into now the interaction of human rights and terminations. So we've talked about terminations, we've talked about the elements of discrimination. So let's look and see how they work together. Sometimes human rights issues emerge in the termination itself. So in the process of actually terminating someone, sometimes there are human rights issues with that process. Other times, the termination is actually the culmination of human rights violations in the workplace, and so it's the last straw kind of thing. Let's look at some examples, though, of where human rights issues may play out in terminations. So maybe you are being terminated while pregnant. This is a big one. And it's a very common issue, unfortunately, in our workplaces. Pregnancy is protected falls under the protected ground of gender. So terminating someone while they're pregnant, in this case, we have a protected characteristic, which is gender. We have a negative effect, which is a termination, and we have the characteristic relating to the negative effect because they're being terminated for being pregnant. So this is a very clear example of discrimination. Another example is maybe you're being terminated because of a physical disability, an illness, or an addiction. There may be a human right issue in here. Maybe you're quitting your job because you're being harassed or bullied and can no longer take it. Again, we talked about this as possibly being grounds for constructive dismissal. I do want to highlight here, as I did earlier too, that the harassment or bullying, in order to make a human rights complaint, it must be linked to a protected ground. So sometimes you may be harassed or bullied because you like a certain hockey team, or I don't know, there's lots of petty things that people can, harass and bully people for. But in order for it to fall under the human rights regime, it must be related to a protected ground. And maybe you're being forced to quit because your boss will not agree to change your schedule to meet your family obligations. So family status is one of the protected grounds. and for being forced to quit your job could be seen as a negative effect. And so this again could amount to discrimination. Again, you would have to draw the link between them. And again, I would warn you or encourage you, not to quit your job before talking to someone as well, because there may be other things, maybe other options. These examples have shown where human rights violations or discrimination may exist. I do not want to give the impression that they are conclusive and that every time those conditions exist, it's automatically discrimination. There's a lot of other things we need to look at as well. So one of those things is evidence. In order to show, or in order to be successful in a complaint for a human rights violation, you do need to have evidence of that. The other thing we look at is, has the legal test for discrimination, has those three elements been met? And then another thing is the duty to accommodate, which is an employer's duty to accommodate their employee. We will be talking about the duty to accommodate in our last webinar, so next month on resolving disputes. So really those examples are meant to give you an idea of when you might want to get more help and when discrimination or human rights issues may be at play. But there are certainly lots of other elements that come in as well. Okay, I'll take a breath. And then another part of when we're looking at terminations, we usually cannot divorce human rights issues from other aspects of a termination. So usually discrimination is only one piece of the puzzle that we're looking at. As I've mentioned, employment standards may come into play. So it could be that an employer is not following employment standards. A very obvious example of this when it comes to terminations is not providing the statutory amount of notice if it's a termination without just cause. There may be issues of someone not being paid correctly or not getting overtime correctly, etc. So employment standards often ties into terminations as well. The other piece we look at is a wrongful or an unjust dismissal. So this is a type of civil claim. So this is a claim you can make before the civil courts in which an employee sues their employer. Usually the basis of those claims is that the employer has not provided enough cause for their termination with cause. Maybe they haven't given enough notice if they were required to give notice of a termination. And this is also where you can make a complaint for constructive dismissal. In order to claim constructive dismissal, you do have to file a civil claim. And the other piece of this puzzle is employment insurance. This is a federal legislation that applies for workers all across Canada. There are rules about who is eligible, etc. And how the termination plays out also may affect your eligibility for employment insurance. As I mentioned before, usually if you quit your job, you're not entitled to employment insurance. So we see these different puzzles, and the big thing I want to note on this is that these different laws, they don't talk to each other. So this is why I'm bringing it up today as discrimination being one aspect of it. Each of these different bubbles, they have their own process. Sometimes they collide with each other and they impact each other, but for the most part, they are separate regimes. And so, for example, if you feel like you have been discriminated against in the workplace, and you were terminated, but then you also were not paid out correctly. If you tried to file just a human rights complaint and, say all those things in one complaint, your complaint is going to be denied because it's the Human Rights Commission only deals with human rights issues, and employment standards only deals with minimum employment standards issues. And so that's where it's important to get help from someone like the WRC because they can help you parse out your claim into the different types of regimes and make sure that your different complaints get to the right bodies in order to get resolved. Okay, I'm also going to make a comment about releases. So if you have an issue with your employee and you raise a complaint, Settling is often a resolution. So we talk a lot about settling issues. It's usually payment from one party to another to settle the issue. There can be other I guess conditions of that, but usually it's the flow of money. Parties, though, or an employer specifically, will usually not settle an issue unless they get a release. And what a release says is that you will give up all your other claims against that employer. So really, it's kind of like an insurance policy for them. They don't want you to come back, a year later and raise a different complaint. If they're going to settle an issue with you, they want it to be, one and done. It's all there. If you've signed a release about one type of issue, but now you believe that you might have another issue, it's important to look at the terms of that release. Because usually a release will say that you waive all of your claims against that employer. And this could include human rights complaints. So let's say you didn't get enough notice, you signed a release, you got more notice, all's good there, but then you believe that you have a human rights complaint. If you've signed a release saying that you will not pursue any more actions against your employer, that may include not being able to pursue a human rights complaint. And generally, the courts or the commission will look to a release and will uphold a release. There may be some instances where they won't, but for the most part, those are generally accepted to bar claims. So just a quick note, if you signed a release, to maybe look at the terms of that release and to get some legal help before you sign a release as well. Okay, I'm gonna take another breath here for a minute before we move into our spotlight on sexual harassment. So, as I mentioned last month, there is a lot of amazing work going on right now to highlight the issue of sexual harassment in the workplace. There is, and this is across Canada, sorry. So Justice Canada has actually funded so many projects across the country that are geared towards preventing sexual harassment in the workplace, educating people about the issue, addressing sexual harassment by providing different resources that people can go to if they are experiencing harassment. And that's where the Workers Resource Center comes in, and they'll talk about their work in a minute here. But they have an awesome program as well to support those who have experienced sexual harassment in the workplace. So we do want to take a minute today to talk through that issue a little bit. So do you believe that you are experiencing sexual harassment at work? If you are, there is help available. Last month, we talked about what sexual harassment is. So we know that it's a form of discrimination based on gender, gender identity, gender expression, or sexual orientation. And it is any unwanted or unwelcome behavior that is sexual in nature and negatively affects you. Not always, but often, sexual harassment is due to a power imbalance. So it's usually someone such as a boss harassing a subordinate. It could also not just be power in terms of hierarchy, but power in terms of, I want you to do something for me. So if you do this for me, then I'll do that for you. So, if you give in to my sexual harassment, then maybe you'll get a promotion or whatnot. So there's often some sort of bargaining that can happen as well. The bottom line is, though, sexual harassment in the workplace is not okay. In any circumstance, it's not okay. How this ties into our discussion on terminations is that often people who are experiencing sexual harassment, they don't report it. And that may be because they fear losing their job if they do. So maybe they'll get fired, or they'll worry that if they report it, the harassment will get worse, or they'll face some other type of negative consequence in the workplace for standing up and reporting the sexual harassment. The flip side of that is someone who reports it, sometimes someone who reports sexual harassment may lose their job. So that fear of losing their job may come true. They may lose it, they may get fired, or the harassment may get so bad that they feel they have no choice but to quit. Or they may even be threatened and forced to quit. This is not okay. The bottom line is losing or quitting your job because you're experiencing or have reported sexual harassment is not okay. And actually, the Alberta Human Rights Act specifically says that someone cannot retaliate against someone else because they've made a complaint about a human rights issue, or they're attempting to make a complaint, or they've helped someone make a complaint. So really retaliating because you've made a complaint is not okay. I want to walk through a couple examples. We looked at 3 last week. We're going to bring one of those examples back this week, and then I'm going to introduce a new example as well to kind of show how sexual harassment can play out in the workplace and how it can play into termination of employment. And we're going to do a quick, after each of these examples, there's going to be a quick poll pop up on your screen for a couple questions for you to answer, just for a little interaction here. So let's meet Alex. So we met Alex last time. So Alex works in construction. Their coworker repeatedly asked them out on a date. Alex always says no. The coworker gets more and more persistent. And Alex's other coworkers and boss just laugh at the situation. They don't do anything to stop it. And so Alex no longer feels comfortable at work and they quit their job. So a quick poll is going to pop up on your screen with 2 quick questions. What type of termination is this? And then I think there's a second question about, is there an issue of discrimination in the termination? Okay, so most people kind of a split here on whether this is Alex has quit or if this may be an issue of constructive dismissal, which again, this may be, like I said, constructive dismissal cases can be hard, but this may be an instance where constructive dismissal, which is an example of constructive dismissal. Okay, I don't know if we have another, I think that's the only question there we have. Oh, I think there's a second question. I'll get Natalie to throw that up. Oh, maybe not. Okay, that's okay. Let's move on to, I guess the only comment I'll make here is there an issue of discrimination in the termination? Likely. So this is an example of sexual harassment in the workplace. It relates to someone asking someone out. So it's unwelcome behavior it could be sexual in nature, and where a toxic work environment's created. And so we can look at the negative effect being Alex quitting their job. And again, termination, there may be some recourse for Alex in terms of filing a complaint and maybe a claim for constructive dismissal here as well. Let's meet Rory now. So Rory is pregnant. One day, her boss asks to meet with her, and during that meeting, the boss makes sexual comments about her being pregnant. The boss makes sexual comments on other occasions too. And a few weeks later, the boss touches Rory inappropriately. Rory is stunned by this behavior. Soon after, the boss gives Rory a written warning of her performance. It notes that if her pregnancy is interfering with her job, that she should find other work. Less than a month later, she receives a termination letter, and her ROE indicates that she quit. So the same questions are going to pop up on your screen. Okay, so some people are saying that this is a termination without just cause. Some are saying this is maybe a termination with cause. And some are also saying that this might be constructive dismissal. Now, in this case, allegedly, she is being terminated with cause. And that cause is that her pregnancy is interfering with her work and she's not able to do her job correctly. And so, presumably, that's the cause. Now, this is actually a case that went before the Alberta Human Rights Commission. This is a recent one, or I don't think it's actually that recent, but 2016. But this was an actual case, and the details are a lot more horrific, and we did not share them today. But this happens, and we can see here how the discrimination in terms of her pregnancy, she was facing sexual harassment, and then she was, discriminated against for being pregnant, and then she was terminated. But that wasn't the only negative effect she experienced. She was also given a written warning of her performance that was, very clearly related to her pregnancy. So in this case, the evidence was quite clear. We can bring this case back next time as well to look at kind of the resolving disputes part of it. But just to highlight some of the issues that can come into play. The other comment I want to raise on this one that was raised in the case is that her ROE indicated that she quit. So the record of employment is something that the employer provides to the employee. The ROE is what you can use to claim employment insurance. Like I said before, if you quit your job, you're generally not entitled to employment insurance. So in this case, they said that the reason for termination was her quitting, which would impact her ability to get employment insurance, which in this case, she was like 7 months pregnant when she was terminated. So now we're looking at, suddenly not having a job and potential issues with being able to claim not only employment insurance, but also maternity and parental leave benefits as well. So you can see how a human rights issue can spiral and have implications in several of those different puzzle pieces we talked about earlier. Okay. I don't want to leave it all in doom and gloom, though. I'm going to turn it over to Quinn because there is help available. If you have been terminated or facing a termination and you believe that there are human rights issues at play or other issues, there is help available. And so Quinn is going to run through some of those different avenues now.
Thank you, Jess. That was great. So yes, my name is Quinn and I'm the Sexual Harassment Legal Specialist at the WRC. So we're just going to spend a few minutes going over some different resources that are available depending on what's happening for you. So first, I'll just talk about the Workers Resource Center, the WRC. So we have many programs that we offer support through. So one of them is our casework program. So if you are having issues with employment standards, employment insurance, human rights, AISH, anything on this list here, you can contact us by booking on our website or giving us a call, and you'll be matched with a caseworker who will work one-on-one with you to help you file the complaints or to give you information based on your specific situation. So like we mentioned earlier, if you are thinking about quitting your job, please know that you can call us and let us know what that situation is, and we can let you know kind of what that will look like, and if it's what the chances of EI and things like that will be. We also offer public legal education workshops. So we have workshops on employment standards and EI and a huge variety of topics. So if you would like more information on that, it's on our website, or again, you can reach out to us. And the program that I'm involved with is the Sexual Harassment Advisory Program. So I offer a 1-hour free seminar on workplace sexual harassment. And we also offer intake and referrals and casework as well. So if you are experiencing sexual harassment at work or you have experienced sexual harassment at work, please know that you can reach out to me via the phone, give us a call, or the website. And I will work with you to go over your case and different options and different avenues for support. And then if you would like to file a human rights complaint, I can help you with that. We just work one-on-one to figure out what the best option for you is and to provide those supports and resources. So next, the CPLE website is listed here, and it is a great resource. So they have FAQs, they have articles, info sheets, all about things to do with what happens if you lose your job, bullying, harassment, minimum standards, occupational health and safety. And they also have some other information on things like landlord and tenant and family law. It's a really great resource. I look at it often when I have some questions about different areas. So I'd encourage you to check out their website as they have lots of good information on there. Next is employment standards. So employment standards is who regulates a few different things. So when you were terminated, did you receive proper notice of that termination? Proper payment of wages, overtime, holiday pay, vacation pay. If you have not received those types of payment or notices, you would make a claim to employment standards. An important thing to remember here is that you have to file a claim within 6 months. So if you are missing those payments, or if you didn't receive proper notice, you can make a claim to employment standards, as they're the ones that enforce employment standard code. If you would like assistance in doing this, please contact the WRC and we can absolutely help you with this. So we also talked quite a bit about the Alberta Human Rights Commission. So you'll see some information here. 77% of complaints cited employment practices from 2019 to 2020, and 14% of complaints cited gender, which of course includes pregnancy and sexual harassment. Now, just to keep in mind, these stats only count complaints that are filed. Many people do not file human rights complaints. Thus, the full picture of what kind of happens is not reflected here. So you can make a complaint to the Alberta Human Rights Commission if you have faced discrimination based on one of the protected grounds. Again, if you would like assistance in this or some more information on this, you can contact the WRC and we can work with you to do this. The Alberta Human Rights Commission also has a great website with lots of different case studies. So if you're just interested in learning more, you can check that out. So finding a lawyer. So the first link here is a community legal clinics. So these are different legal clinics across Alberta that offer free services or pro bono. You can click on that, or you can search that website there. It is a CPLE website, and it offers a directory of resources and a list of different clinics throughout all of Alberta and what those clinics offer. So that's a great option. There is also the lawyer referral service, which is run by the Law Society of Alberta. So it helps connect clients to lawyers. So if you go give them a call or check out their website, you will get the contact information, typically for 3 lawyers. And each of them typically provides a 30-minute consultation. So they won't offer you legal advice, but they will give you a consultation. So that's just a great resource if you're looking for a lawyer, or you know, the legal clinics are great too. They do things like ID if people need ID, things like that. So these are just some good options to get connected to legal support. So this is the Alberta One Line. So these are supports for people that have experienced sexual violence. So this is run by the Association of Alberta Sexual Assault Services. So it's a phone number that you can call or text 7 days a week if you've experienced sexual violence. And your call or text is answered by specially trained professionals who will give you resources, supports, connect you to local supports. And this is province-wide, which is quite unique. And it's a really great resource. And just keep in mind, this is also for those who are supporting somebody who has experienced sexual violence. And this includes sexual harassment, of course. So If you've experienced sexual violence, if you know somebody who has, you can reach out to this line for different resources and supports in your area. So those same folks are bringing us the Moments Matter campaign. So we know that workplaces that are respectful and safe discourage sexual harassment. So this is an awareness campaign, and they are bringing awareness to healthy, respected workplaces, and the moments that make those workplaces respectful. So you can find lots of really great information on that link there. There's lots of different information for employers and managers about how to make your workplace safe and respectful, and what that impact is on the employees, and how that makes it safer for everybody and discourages things like sexual harassment. So finally, we'll get a tip sheet that you can reference that covers a lot of what we discussed today. It will also be available on the CPLE website and on the WRC website, and it just covers a lot of what we went through today.
Oh, and those will also be available in French in the coming weeks as well. So we have partnered with our good friends at AJAFA, and they are translating them into French for us as well. So just a side note. Perfect. Thank you, Quinn, for running through all those excellent resources. As you can see, there are a lot of different avenues available and different options. But as Quinn pointed out at the beginning, the WRC is kind of a great one-stop shop if you have employment questions, and they can help point you in the right direction and support you in making different complaints or whatnot. We are now going to take some questions. We have about 10 minutes for some discussion and questions, or just over 5, sorry. So we will open up the line. If you have questions, please post them in the Q&A chat. I see there are a few already, so we are going to dive in, but you can certainly add your questions as you see fit. So the first question is, are there any special rules that apply to dismissal during probationary period for a new hire? Is just cause required? Is there any obligation for the employer to tell the terminated employee what the reasons are for the dismissal? Is notice or payment in lieu required during probation? Carolyn or Quinn, did one of you want to answer that question?
Sure, I'll take that one. So the probation period is typically, it's 3 months, and it's a feeling out time. So the employee is going to get a good feel for the employer is going to get a good feel for the employee. And then after that period, they would look at whether that's a good relationship moving forward. So under the probationary period, no, you're not required to disclose with or without cause. You're not required to provide a reason, and you're not required to provide any notice. And that is true employee and the employer. So just know that that is sort of the time where everyone figures it out. After that, rules will apply, but under that 3-month and under window, it is not required, or 90 days, I guess I should say.
Perfect. We have another question here about, has your firm explored the termination of non-union employees due to the vaccine mandate? I can answer that, Carolyn, unless you would want.
Just a point of clarification, we are not a firm. So it's important to understand that the Workers Resource Center are not lawyers either. What we are here to do is advise you on your rights and entitlements under the legislation in Alberta. So we are not acting in a legal capacity, we act in an advocacy. So I just want to clarify that before I hand that to you, Jess.
Absolutely, thank you. And I'll also clarify as well, while I am a lawyer, I work for the Center for Public Legal Education, and we do not provide legal advice services either. Our mandate is legal information. So I cannot answer that in terms of giving legal advice. What I can say, because we anticipated a question like this coming up, because this is the world we're living in right now, is that this is a complicated legal question. We are operating in what I would describe as a legal limbo right now. This is an unprecedented pandemic that we're in, and unprecedented also in the sense of there's not a lot. This is something that the law has not considered either. I will say kind of two things. So under Alberta Human Rights Act, there is an allowance for what we call bona fide occupational requirements. So Alberta Human Rights Act recognizes that in some cases, there are characteristics that are required for an employee to work at a certain job. So for example, if a job requires someone to go up and down stairs all day, then someone with a physical disability preventing them from doing so might not be a good fit, and that would be a bona fide occupational requirement and not necessarily be discrimination against that person. Under the Charter of Rights and Freedoms as well, where we have or extensive rights there. Our rights are never absolute in the sense that we are guaranteed those rights and that's it. We do have Section 1, which allows for reasonable violations of rights and freedoms. Now, there is a very strict test to determine a legal test to say what is a reasonable violation of rights and freedoms, and it is certainly not something that is taken lightly. And this plays out in the courts, quite honestly. So this exact question of termination of non-union employees due to the vaccine mandate, this is something that I expect that we will see play out in the courts in the next few years. As challenges are made, and there will certainly be arguments made on both sides of the issue. As with any good legal issue, there's arguments to be made on both sides. I do also want to kind of give a caveat, is that as we see this play out in the courts, which I fully expect that we will, just given the nature of it, the courts also make decisions based on or they may make decisions for certain industries as opposed to others. So if we see the courts making a decision about one type of industry, it doesn't mean that that decision will necessarily be suitable for other types of industries as well. It may be that that's the case, but it may be that it's not suitable. We certainly see that playing out with other types of rights, and that it may be suitable in one context, but maybe not in another, or there may be cases where it's suitable in all contexts. So I guess I would just be my kind of, tip, I guess, as things play out in the courts, that it's not going to be, blanket decisions necessarily. We may see it playing out in different ways in different industries, different fact situations, because really when we take things to court, generally they are quite fact specific. Is what we use. So it is based on a certain set of circumstances that if it's not exactly the same somewhere else, then that decision may or may not relate to a different situation. So that's all I'm going to say about that today on vaccine mandates. Just kind of give that kind of preface. I'm just going to leave it there. We have a question here about perceived disabilities under human rights. What are these? I don't, Carolyn or Quinn, does that, perhaps the person who asked that question could maybe clarify, unless Carolyn, something pops out to you as what that might be getting at?
Yeah, I'm not really sure what that means either, because the thing is that under human rights, under the Alberta Human Rights, disclosure of a disability does not trigger the duty to accommodate. What triggers the duty to accommodate someone with a disability is the physician's information that outlines the accommodation requirements. So even if it's perceived that one may have a disability, there's no special accommodations put in until that person requests them with the supporting medical documentation. So I don't know if that's what that question's getting around, but that's just sort of some general information about that.
Perfect. If whoever asked that wants more information, then if you could just ask a follow-up question, that'd be great. Okay, the next question we have here is, are there time restrictions on how long employees have to file a claim for constructive dismissal and harassment? Carolyn or Quinn?
It would depend what you're filing it under. So the important thing that we want people to recognize too is that there are different pieces of legislation like this, and they all have different timelines and different interpretations. So for example, if you were owed termination pay, you would file that through employment standards. That would be 6 months that you have to file. But if you were circling around and you're using the terms constructive dismissal, that's a legal term that would typically be relegated to a civil suit or filed as a civil claim. In which case, if you're filing a civil claim for that, you would have 2 years to file. So you have to, and that's why we're kind of correct us, is you have to be really specific in the legislation that you're referring to or the legal avenue you're referring to. So human rights necessarily talk to employment standards, who wouldn't talk to employment insurance. They're all guided by different pieces. So it's really important to understand that each piece is going to have a different timeline, but typically for small, call them, or civil suits, you would have 2 years to file. So for example, if you missed out on the window to file your owed termination pay through employment standards, you could file a civil suit. Just know that there are fees to filing. You get them back if you're successful, but they're cost. So sometimes people really need to balance out whether trying to get that $200 of termination pay is worth filing the $150 fee and trying to get that back. It's a bit of a kind of a personal decision.
And then I think Quinn mentioned earlier, like the Human Rights Commission, you have to file a complaint within 1 year of an incident of human rights violation. So there's all different timelines that come into play, which is why I guess the important thing would be to get help as soon as you can so that you don't miss any of those timelines. Okay, we have one more question here. Being on medical, sick leave, and filing a WCB form and then got fired, does this qualify for wrongful dismissal? I am going to preface this before anyone answers and just saying, again, we cannot give legal information during the seminar. And so we can give legal information only. And so Carolyn, if you want to answer that in some way, again, knowing that we can't advise you specifically on your situation.
Yeah, I think the thing that people need to realize is there's some changes. So the provincial government enacted Bill 32, which was Cutting Red Tape Act. There's some questions around discrimination in regards to that, in the sense that that legislation stated that employer required to necessarily hire an employee back after a return from medical leave, but that runs a bit counter to what the Alberta Human Rights Act legislation supports. It's not really because there are things in flux. So I would say if you have specific questions around your situation, give us a call. We can review the paperwork and sort of determine what the potential next steps might be. But it will be interesting to see how certain legislation runs counter to other legislation as well. So
perfect. I know we're running a couple.
Pick up the last question. Yeah. Sorry, I'll just answer this one. Will you be doing a similar presentation for union environments? We do not. And the reason for that is every unionized workplace would have a collective agreement. And that collective agreement is a legal document between you and your employer. And your collective agreement is required to have the same or better than the current employment standards under the legislation. So we would not be the best people to talk to about that. The best people to talk to about your legal document with your collective agreement would be your union shop steward or your site steward, because they could advise you specifically on your collective agreement and also what your legal grievance process is as well.
Perfect. Thank you for that. I know we've run a few minutes over time, but we wanted to get to all the questions. So for those of you that stuck around, thank you for doing so. Yes, thank you again for all of your interaction and your questions today. Hopefully this was informative. Again, when you leave, we would ask that you just complete our short 30-second evaluation form. Just lets us know how we're doing today. And again, if you have not yet registered for our third installment of this series, which is resolving disputes, which we'll talk a little bit more about if a human rights issue arises, what are some of the steps you can take to resolve that dispute. So we'll get into some of these processes that we've been alluding to. We'll dive a little bit deeper into that next time. So thank you for joining us and have a great rest of your day. And thank you, Carolyn and Quinn.